And welcome. I'm Maithili, and I'm so excited to kick off this Fireside Chat. Thank you so much for spending your Saturday evening with us, and depending on what part of the world you're joining from, Saturday morning or afternoon. We are thrilled to have you with us. Just a few housekeeping rules to begin with before we get to the more exciting part of the event. This Fireside Chat is going to go on for about an hour. We will take questions at the end of this Fireside Chat, so please put your questions in the Q&A box. Any comments you might have should go into the chat box. While asking a question, it would be great if you could state your name just so that we can attribute the question to you when asking it to the panelists. One request though, please be respectful in your questions and in your comments. And a quick disclaimer before we sort of again go into the more exciting part is that all opinions that are part of this conversation are strictly personal and not attributable to any institution. And now over to you, Diana.
Microphone.
Apologies. Right, thank you so much. This Fireside Chat is aimed to bring global perspectives on pertinent topics, and it's presented by the Harvard Law School Women's Alliance, India. It's an international organization for women graduates of Harvard Law School to foster community, continuing education, and leadership. We also have incredible partners for the event, Bar and Bench and Daksha Fellowship. So without much ado, we would like to introduce you to our speakers for tonight, even though they need very little introduction. Our first guest for today is Dr. Danilo Turk. He's the former president of Republic of Slovenia. Prior to his term, he was the United Nations Assistant Secretary General for Political Affairs. Dr. Turk has played a multitude of roles in his life as a lawyer, diplomat, politician, academic, devoting his time to humanitarian work, international cooperation, and international law. We're indeed really privileged to have you here.
Thank you. Thank you.
We also have with us Justice Dr. Dhananjay Yeshwant Chandrachud. Justice Chandrachud is a judge at the Supreme Court of India. He has a master's in law and a doctorate from Harvard Law School. During his tenure at the Supreme Court, he's delivered path-breaking judgments on Indian constitutional law, human rights, gender justice, and public interest litigation. Thank you for joining us, Justice Chandrachud.
Thanks, Maithili. Pleasure to be here.
Thank you. And we also have Professor Laurence de Chazournes. She's the Professor of International Law at the University of Geneva School of Law and the Director of LLM in International Dispute Settlement, MIDS. She is a recognized practitioner and advisor to many international organizations, states, and non-state entities, and has acted as an arbitrator in numerous dispute settlement fora. Thank you so much for joining us, Professor.
Thank you very much. It's a pleasure.
And as for us, I'm Maithili Parikh. I'm a junior counsel at the Bombay High Court, working in the chambers of Senior Counsel Zal and Diarugina, where I practice commercial disputes. I have an LLM from Harvard Law School, class of 2019, and I'm also the Chief Strategic Officer at Her Foreign, which is a platform and community for women in law.
And folks, I'm Diana Phillip, and I work as Senior Advisor, Government Relations with Dell Technologies. I too have a Master's of Law from Harvard Law School, and I'm the co-founder and co-chair of HLSWA India.
Now that we have the introductions out of the way, let's dive straight into our questions. Coming to my first question. In a world that is becoming increasingly polarized, it would be interesting to examine the role of dissent and diversity in democracy. Justice Chandrachud, you have earlier opined that dissent is the safety valve of our democracy. Could you elaborate on the role of judicial and individual dissent in democracy, and also touch upon the differences between the US, where judges more frequently give dissenting opinions, and India?
Thanks, Maithili. There are two parts to your question, and I'll deal with both of them independently in a couple of minutes. To answer the first part of your question, I'd like to really emphasize what I said in my dissent in the Romila Thapar case in 2018, which is that individuals who assert causes which may be unpopular to the echelons of power are yet entitled to the freedoms which are guaranteed by the Constitution. Dissent is a symbol of a vibrant democracy, and voices in opposition cannot be muzzled by persecuting those who take up unpopular causes. That's what I said. Now, nowadays, whenever you really take up the right of individuals to dissent in a democracy, our discussion inevitably gets caught up in the means and the method of expressing the dissenting opinion. However, we tend to forget the core premise of that discussion, that while we may all disagree on how to express our dissent, there is an agreement implicit in our constitutional framework which acknowledges the importance of dissent. Therefore, as a form of government, any democracy must accept that there will always be those who disagree with the views of others and will express their disagreement. The expression of dissenting opinion must not be seen as a hindrance to policy, but rather as its criticism from which one can learn to make better and more well-informed decisions. So that in any democracy, dissent by individuals offers a much required breath of fresh air, a sort of a counterweight, so that the rights and interests of everyone, including those on the margins, are taken care of. So as a constitutional goal, there are not many more which can be put on a higher pedestal. But when we talk of judicial dissent, which is the second part of your question, there's a slightly different consideration at play. Judicial dissent, unlike individual dissent, does not often arise from a difference in one's political viewpoint from the majority. Rather, the basis of most judicial dissent is disagreement in an interpretation of law between different judges. So in many ways, judicial dissent can be a cause of simple intellectual disagreement as opposed to individual dissent about ground realities or political realities. However, the value which is ascribed to judicial dissent is also often tied to the nature of the case where it occurs and the larger socio-political issues in any society surrounding the case. So therefore, even a judicial dissent in some cases no longer remains an intellectual disagreement on the interpretation of law, but it's a disagreement about the most fundamental principles of the Constitution and our democracy, and how we envision as judges our society going forward should take us. Now, coming to the second part of your question about the US and India, I think it's very important at the outset to notice two crucial differences between the United States and India. First, the Indian Supreme Court is a polyvocal court, unlike the American Supreme Court. So we sit in multiple benches of 2 judges, 3 judges, 5 judges, 7, 9, and in some cases it's been also 13. The American Supreme Court sits en banc as one court of 9 judges. Second, the Indian Supreme Court does not limit itself only to questions of constitutional importance or significance, but we are also a final court of appeal. So we are both a constitutional court and an appellate court, whereas the US Supreme Court deals essentially with only constitutional cases. Now, these two are very significant as a factor in the extent of dissent that we see in the US Supreme Court and in the Indian Supreme Court. The US Supreme Court often ends up adjudicating only those cases which have strong ramifications for constitutional democracy, in which 2 justices are more likely to disagree. Our Supreme Court, on the other hand, does a lot of regular work where the extent of disagreement may therefore not be as pronounced as, say, in the US Supreme Court, particularly in your regular or routine appellate work. But having said that, let me substantiate my argument by saying, with referring to my own judicial career, I've been on the bench of the Supreme Court for 4 years, and I have delivered dissents in 7 very crucial constitutional cases. One was, on the entry of women of a menstruating age into temples, into a particular Hindu temple, which was the Sabrimala temple, where I struck down that restriction as being fundamentally violative of constitutional values. Then I delivered a dissent in the Government of India's biometric program for all citizens. The majority upheld the program, and I was of the view that the program was unconstitutional. Then there have been dissents in several other cases, including on whether you can have video conferencing in family matters. My colleagues felt that you can't have video conferencing in family matters of mediation. And I felt that, well, that's very anachronistic not to have video conferencing when you have one spouse in Silicon Valley in California and another spouse in Bangalore. How do they connect except on the video link? But what I want to, I'd conclude with this really. If one looks at the nature of the cases where you have had dissents in India, it's not hard to see that dissents have arisen in the crucial cases which affect constitutional democracy, the rule of law as we judges envision it. And I think the power of judicial dissent is extraordinarily important. Unlike the civil law tradition where all judges speak with one voice, in the common law tradition which we follow, I think the heart of judging, the core of judging is that it's an expression of yourself. I think if you really ask me what what I've learned in the last 20 years is that it's a form of self-expression about what you consider to be a just society for the future. So when a judge dissents, you're giving expression to some fundamental values of the Constitution which are embodied in your heart. And I believe if you don't have judicial dissents, then the judge's craft would not really be true to its own conscience. So that really broadly sums up what I would like to say to your question.
Thank you for that. It comes straight from the heart, I believe. Dr. Turk, you once said, and I quote, "Today it is urgent to intensify efforts to develop greater understanding among different cultures and acceptance of their diversity." Now, as someone who was an independent presidential candidate elected by popular vote, would it be possible for you to comment or give certain insight into how do you think that could be really achieved?
Well, thank you very much, Diana. And but you see, after having listened to Justice Chandrachud, I cannot resist the temptation to make a short comment on the distinction between common law and civil law systems. Now, I'm from a country which is civil law tradition country in the continental Europe, and which has now about 30 years of experience with constitutional justice, constitutional court in the fullest meaning of this word. And I can say that the dissenting opinions are really very important in the whole process of interpretation of constitution. So I would go very much in the direction of the tradition in India, I would say. Judges do express their views, their interpretations from their heart, and they are very meticulously argued dissenting opinions. They are very strongly argued, and they are very much noticed in the general public. And that's very important, so that the public gets the judgment of the Constitutional Court, but at the same time also the most important, the best argued opinions of dissenting judges. This has become a culture now. So I think that the distinction here is a little less than maybe was there originally, which leads me to the core of your question, Diana, about different cultures. Now, of course, culture is a complex matter, and that includes law as part of the culture, as well as the current example showed. But of course, if one takes a global view, cultures are many, civilizations are many. And of course, the question is, how does one handle this complexity? One has to remove some illusions, like, for example, that intensity of communications or quantity of communications per se helps. It doesn't, because understanding among different cultures is basically an ethical question. That relates to ethics, the ethics of every individual and the ethics of every community. And the key element of that ethical base of intercultural communication is respect. Now, I think that respect is essential, both in terms of self-respect and respect of the other. That's essential ethical requirement and is ethical postulate for managing intercultural dimensions of politics, law, or whatever communication is in question. So Now, respect again is a difficult quality to attain. It's not something that comes naturally, and that's something that doesn't require any work. It's really an ethical requirement which requires, among other things, also law. Because in actual societal relations, the need for respect is clearly defined by law, more or less clearly defined by law. So law has an important ethical function in this regard. And when people say, well, I respect the law, one has to understand that that means also respecting the basic ethical postulates of the law, where respect is always in the core, I think, in all legal systems. But of course, this is not the end of the complicated story, because law is sometimes subject to different interpretations. If you take, for example, freedom of expression, which of course has a very wide range of different interpretations. And I would add geography as well. And I would like to end with this, with a small excursion into history. You see, in Europe, we had, after the invention of the printing in 15th century, we had a period of religious wars from early 16th century to mid 17th century mainly. And at that ended with an agreement about an important legal principle, which was of course embodied in different partial peace arrangements before. Cuius regio eius religio, the one who is the master of a region, of a territory, of a state, is also the master of religion. Now this, of course, is a bit crude, but it's quite helpful, because the holder of political power, again, has to be respectful, has to respect the origins of his or her power, and has to make sure that the prevalent thought of that region is respected. And that is obviously, in most cases, reflected in the law, because law is the instrument which defines respect and delineates power among various polities. Now, this may sound a bit abstract, but I guess it's quite relevant in today's complicated world. And that's the way forward. You see, I'm an international law person by DNA, and therefore I always come to this kind of conclusions when I talk about more complex political issues such as intercultural relations.
Thank you, Dr. Turk. That was very insightful. Professor Laurence, I wanted to ask you, do you see a shift in the role of international courts, especially the ICJ, in redefining the contours of democratic governance, including upholding of human rights and environmental protection?
Yeah, first of all, I'd like to, like Dr. Turk, I'd like to say that being a civil law person, trained person, I just think that dissenting opinions are also part of our daily life. And being an international arbitrator, I have dissented, and I feel the same that what was exposed before. It's very important when the principles at stake are important to you. Now, speaking about international law and the International Court of Justice, one thing I'd like to say is that international law is really linked to the domestic law systems. So we're going to be speaking of the International Court of Justice, but I think that the domestic courts play an even greater role for implementing domestic law and international law. Now, when you look at what the International Court of Justice is asked to do, you will see that the court, in fact, more and more is dealing with issues of democratic governance as you frame them. You think about self-determination, you think about racial discrimination, you think about genocide, you think about death row, you think about death penalty. The court has touched upon all these issues, and you see that at the international level, in fact, the court has told states that there are certain things that are required by international law that has to be implemented at the domestic level. Now, if you take environmental law, it's the same. Like domestic courts, the International Court of Justice is now telling states, The environment impact assessment should be respected. If you have a project, you should consult the concerned people. If you are going to have or to authorize a project, if it damages the biodiversity, the wetlands, you should take that into account and so on. So as we see it, in fact, more and more, the International Court of Justice is asked to deal with issues which are going to have resonance at the domestic level. And I think it's very important because as I started, what happens at the international level should in fact have resonance at the domestic level, and the courts, the legislators should help international to be implemented in an effective manner. So yes, the International Court of Justice has opened its door to democratic governance.
Thank you for that. Clearly, I can see there's a lot of interconnection between the International Court of Justice and the domestic system. Thank you. It was very insightful. I'd like to go into a little different territory here. Speaking of women's movement, which seems to have made great strides. But there are also, and especially in the recent times, we see that there's a shift in conservative powers across the world. So we wanted to discuss the impact of that. And Dr. Turk, this is a question for you. As someone who has had a tremendous experience, working in the global politics and peace and security across the world, do you see the role of women growing in these fields?
Sure. Clearly, the answer is yes. It's very simple. It's yes. This is the historic trajectory. Women are gaining in importance. They are more and more involved in the decision making on political issues, including the issues that are relating to peace and security and so forth. They are not, of course, yet fully equal in kind of numerical strength or the impact, but I think the tendency is clearly there, and it's historical. Now let me give you two personal experiences. You see, the first one comes actually from my mother. My mother, during World War II, she was 13 years old when the war started, and her entire family was sent to Germany to a labor camp. So her education was interrupted for 4 years. And that, of course, is terrible, because one cannot recuperate this kind of very long break in the educational process. As a result, she insisted that her two children, me and my brother, two boys, have to study. And she was absolutely insistent on this. And little by little, I understood how important that is. And that came as a result of her experience. And when I look at my colleagues in studies at university, half of them were girls, half. In law today, in Europe in general, I think women are about 1/2, perhaps a little more. And that of course has been the historical tendency, which I think is becoming global. I was in various places around the world, and I can tell you an anecdote from Mongolia. I was representing United Nations at a conference in Mongolia, and I had a press conference, and most of the journalists were women. The Minister of Information who was managing the conference was a man. And then when the conference was over, I asked him, why are all the journalists women here? Is this because UN is a soft subject and, women journalists came? I said, no, in our country, journalism has become a female profession. Because men are mostly in security, or they're lazy in schools, they don't finish this and that. Girls study much more, and that's how it's changing. When I came back to New York, I discussed this over a dinner with various ambassadors, and say, well, it's the same thing happening in every country. So, one can clearly see physically, not having to study the phenomenon, that this is happening. It has to do with education primarily. It has to do with technology, because now the computers and everything that goes with that, internet and so forth, gives an additional opportunity. And I'm sure that this is only going to grow. Now the pandemic has added another layer because women leaders generally perform better than men leaders. And that will have an impact in the future. Look at New Zealand, for example, which has become a celebrity cause globally. In Europe, obviously, Germany, it's Finland. So this helps to advance the cause of equality. Now, equality obviously is never a perfect mathematical thing. I mean, it's political. But I think the tendency is clearly there. It's unstoppable, irrespective of occasional regressions like we see today in Poland with this pretty terrible law, which is going to be repealed at some point, I'm sure, because the opposition of the public is simply too strong. It can actually succeed temporarily, but it cannot prevail historically. So I think the historic tendency is clearly defined.
Thank you, Dr. Turk, for sharing your experiences with us. Professor Laurence, the world of international arbitration is often called pale, stale, male, and various initiatives have come about to the forefront in response to this, such as the pledge. As someone who's been arbitrator and counsel in various war rooms across the world, how do you see gender diversity in arbitration growing?
So it's a difficult question. What I'll say is that I'm optimistic, but I think it's a slow process, really. And the pledge is something, as we say, there are words, but then you have to put them into effects. And the first thing I'd say that, yes, men have to do an effort. They have to open the doors of the club, if we could speak in those terms. I think it's also a responsibility of the women, and in law firms, those who are appointing are men and women, and they also have to play a role. When in states, when the state representatives are appointing people, it's also a sharing of burden between men and women. But more than, an issue of men and women, I think it's also a cultural issue. And it brings us back to the first question, is that, yes, you can say that you would like to have as many women as men, but there are hurdles. There are cultural hurdles, there are racial hurdles, and so on. So I think to be able to have more women at more important positions, you also have to put that in a cultural context where you will have to deal with these issues. And I'm not so sure that all our societies are ready for that. And we have to fight. And that would mean that, for me at least, it's not just a question of having women somewhere. It's also a question of having diversity and not just a certain type or category of person at certain position. So as Dr. Turk said, it's not, I don't think equality is going to bring us very far. It's a deeper debate. And I'm sure that your generation, the young generation, you're going to overcome all these hurdles, and we're going to be able to have this diversity that we need at the international level.
Thank you, Professor Laurence. That's a very, very interesting point you brought out, and especially the issue of diversity. And I hope at least it's not, even if not our generation, our next generations to come will be able to overcome that bit. I have a question now for Justice Chandrachud, and this is again referring back to your decision in the Sabrimala case. Just a little bit of a context there for the global audience is the Indian Supreme Court judgment that held that the practice of preventing the entry of women in a specific temple in Kerala, which is in the southern part of India, as unconstitutional. There was a vitriolic reaction against the verdict. Could you comment on striking the right balance between societal beliefs and religious customs to reflect notions of gender equality?
One of the unwritten rules of the game of being a judge is that you don't talk about your own judgments. But now you're inviting me to make a breach of that norm. But just taking off from what Dr. Turk said and Professor Laurence said, about having more women in important positions of empowerment and authority. My icon, which is incidentally Ruth Bader Ginsburg, Ginsburg was asked how many women in the Supreme Court would be sufficient according to you. She said, well, why do you ask me this question? 9, she said. I'd be satisfied when all 9 are women in the Supreme Court. And I think that's my take as well on the empowerment of women. Coming back to your question, just for the international audience, and I'm not going to really defend my judgment because it's obviously been the 2 viewpoints on a critical issue like this, which was that the custom in a temple said that women between the ages of 10 and 50 would not be allowed to enter the temple because that was stated to be the menstruating age, 10 and 50. They have a ballpark figure. And we said, and the reason for that was that the deity is considered to be celibate, and therefore the presence of a woman would affect the celibate nature of the deity. That's the belief, that's the custom, which of course we respect as human beings, as judges, but that has nothing to do with the constitutional question. Now, we struck down that, and we said even a custom is subject to constitutional values and constitutional rights. And that therefore, there is nothing in the religious sphere which is really private, because religion essentially has a position in the public space of the nation. So therefore, we said that even a religious custom is amenable to constitutional control. And India has a long history of temple entry movements, because not merely women, as in this case, but the Dalits, the untouchables, were excluded from temples. And a part of the constitutional movement for freedom was not just the movement for political freedom in India. You can't understand the constitution by construing it merely as a document for the transfer of political power from a colonial regime to a homegrown regime. But it was also a movement for transformation, for a transformation of society. And therefore, our constitution really reflects this very deep-seated aspiration for transformation in Indian society. So we in religion, we follow in the Supreme Court what is called the essential religious practices test, which is that the Supreme Court will decide, or the court will decide, what is essential to the religion. And I criticize that test, and I have suggested that you must have a different test, which is the anti-exclusion principle. Which means really this, that even if a practice is essential to religion, if it perpetrates the exclusion of a certain class of society, then that exclusion is amenable to constitutional standards. So we have an article which bans untouchability in the Indian Constitution. And I said to exclude a woman who is in the menstruating age group from praying in a temple really makes her into the position of an untouchable, involving basic issues of purity and pollution, and therefore it infringes constitutional safeguards. Now, interestingly, there was a dissent in that, a very beautifully written dissent, and in fact, my colleague, Justice Indu Malhotra, she and I are now sharing the bench at the present point of time. But an identitarian analysis of the dissent would be too reductive. There's a perception that, well, because you're a woman judge on the Supreme Court, you must necessarily take a particular viewpoint. And I think that's wrong. And that's exactly what Professor Laurence said. And that's not just a question of having women, but having a question of diversity. And that's more important than anything else. So we both agreed on this, that the court has the jurisdiction to scrutinize essential religious practices. But she said that, well, the court would ban only oppressive or pernicious practices, and not every religious practice. But that was where we really parted company, so to speak. And where we said that the majority said that we can, there is constitutional control which can be exercised over fundamental aspects of religion, insofar as religion has an interface with the constitution. So that really is the distinction between the majority and the minority view. But our aspiration for gender justice is not just confined to the religious sphere. As you know, recently I delivered a judgment in the month of the end of February and March, opening up the armed forces for women. So as a result of our judgment, which has been accepted, of course, by the government wholeheartedly, we have opened up the army for service on a permanent basis for women, and the Navy, and of course the Air Force is already, we have fighter pilots now who are women. But the Supreme Court of India has opened up the space for women to join the army as well as the Navy on a permanent basis. Interestingly, the government told us in the Navy case, we can't have women because our Russian warships don't have toilet facilities for women. And we said, sorry, this is not constitutionally acceptable. And that can never be an answer to deny a woman the right to have permanency in the armed forces. And I think it's a matter of tremendous satisfaction for me as a judge to see women increasingly assuming positions of importance. They're coming out of the law schools. They're joining the district judiciary in India in very large numbers. The higher judiciary, yes. I would aspire to what what RBG said, that you need to have more women in positions of power and empowerment and authority.
Thank you, Justice Chandrachud. That was very valuable, especially thank you for highlighting that particular quote by RBG. Now turning to something that we are all living through, the pandemic. COVID-19 has brought about many disruptions in the world and has also brought along some opportunities. Dr. Turk, in your opinion, is the pandemic response slowing due to global politics, particularly with wealthy governments stockpiling vaccines, leaving poorer nations without immunization? And what do you believe is the way forward through this?
Well, I think that the pandemic has told us, has convinced us that health issues are still largely within national jurisdictions and local management. That's the reality. And we have discovered, or we have become more aware of this reality, even in European Union, which is considered to be a fairly integrated international regional system. But even there, it was discovered that health sector is very much under national regulation, or in a federal country like Germany, federal units have their roles and so on. So that's the reality which we were not sufficiently attentive to before. So perhaps the expectations about the capacity of international organizations to organize an effective response, that was probably unrealistic. It is as simple as that. And we have seen that the responses, the effectiveness of responses to COVID-19 pandemic varied very significantly. In East Asia, it was generally much better because the experience in those countries was different and the ability to organize quickly was much stronger. In the West, in much of the countries, many of the countries in Asia and in Latin America, in Europe, in Americas, the response was clearly inadequate. So that was the initial part. What happened subsequently brought additional problems, and one of them, I think, which is a very significant factor of slowing down multilateral cooperation, is what is called vaccine nationalism. We have seen a great deal of vaccine nationalism in the process of development of vaccines. And even now, it's clear, well, I shouldn't say it's clear, it seems that the prevalent argument around development of vaccines is national or transactional between different countries. And that's not adequate. Obviously, I'm aware of COVAX facility, 180 countries basically agreeing to cooperate in the production and distribution of vaccines once they become available. But I'm not sufficiently aware of anything that would convince me that that after the vaccines are there, the vaccine nationalism will slowly kind of diminish or evaporate. It doesn't look like. But let me be a little provocative here. I think in Asia, where you have China with great capacity of developing the vaccine and also production, and India, which also has great capacities, in particular in the field of production, wouldn't it be wonderful and in a way natural if there was some joining of forces there? Because the world will need enormous amounts of vaccines, and this will have to come from countries which are sufficiently large, who have sufficiently large capacities to help. The other day, I saw a picture in the newspaper showing the ruler of Dubai, Sheikh Maktoum, in the United Arab Emirates, being vaccinated by a Chinese vaccine, which looked to me like an act of bilateral propaganda. Then we all heard about Brazilian President Bolsonaro, who said Brazilians will not be guinea pigs for Chinese vaccines. Again, a very unfortunate nationalistic approach. I do not know what is the thinking in India and China about the possibility of cooperation, of joining forces. You see, as I said, I want to be a little provocative here. And it would be really great if we found examples which would show, all right, there are countries which are able to go beyond the initial self-preservation based attitude or reaction into something which is more effective and also more promising for the future.
Dr. Turk, you've left us with something extremely scary. There has to be cooperation, and yet we're indulging in vaccine nationalism. Gosh, maybe I'll move on a little bit here. Justice Chandrachud, technology, and in this we've seen, especially in the context of COVID, it's been a boon, I would say, and certainly, you know, COVID has put a spotlight on that. But technology is both also dependent on, you know, and also has an impact on socioeconomic development. Now, as the chairman of the Supreme Court of India's E-Committee and a proponent of digitization, what is your perspective on the impact of unequal access to technology and your thoughts on digitization of judicial processes across India?
Let me share with you, before I go into the nitty-gritty of your question, two abiding pieces of imagery, which I think would never leave my mind of conducting court. In fact, I conduct court sitting right here on the video platform every day. And my two colleagues, Justice Indu Malhotra and Justice Indira Banerjee, are in their chambers, and we are all linked on the screen and we hear arguments. But the two abiding images which I have is an image of a young lawyer for the state arguing before me a couple of months ago. And as she was arguing, I could hear a baby crying in the background. And I just felt this was so tremendously empowering. And it was inspiring for me as a judge. I felt I was inspired by this young lawyer sitting in her house, addressing sitting in her apartment, addressing the Supreme Court of India on a very crucial issue of labor welfare, and in charge of her baby. And another thing which happened 2 days ago, and this was a man who was addressing a male lawyer who was addressing us. And while he's addressing us, there's some little voice comes in the background, and you have suddenly this pink dress which comes and floats into the screen. And he was extremely, apologetic. He said, "I'm so sorry." And so I said, "Is that your child?" He says, "Yes, I'm doing some babysitting as well." So he said, "Let's come and let's talk to your child as well." So these two, of one a woman and one of a man, online in court, arguing serious issues of law and fact before us, but able to look after their families in this time of very, very serious public health crisis. I think these are the two abiding images. Going back now to your question, after the lockdown was declared on the 23rd of March, the Supreme Court started functioning completely on the virtual platform. We have 17,000 courts in India. We have 3,200 and odd, 3,300 court establishments. Every one of our courts had to go online because otherwise justice would have had to shut down. And thanks to technology, we were able to avoid a chaos on matters of personal liberty, where somebody who requires bail, whose personal liberty is involved, has to be heard that very moment. And our courts were able to deal with that challenge. To give you just one estimate of the figures, from the 23rd of March till the 19th of August, actually I have even current figures, the Supreme Court has taken up about 15,996 cases, almost 16,000 cases, and disposed of 4,300 cases. This is a tremendous feat for a court of our dimension. We constituted about 1,000 benches of the Supreme Court. 50,000 lawyers have participated in our hearings during the course of the proceedings. The district judiciary in India, 2 million cases were filed during this period, and they have disposed of almost 925,000 cases during the period of the pandemic. We have now in India what we call the National Judicial Data Grid, which is a data repository of every court in India. And the NJDG, as we call it, it holds data of 4.5 million cases, which are pending before the high courts. It also holds data of 33.6 million cases, which are pending before the district courts, and of all the cases which have been disposed of since the NJDG was set up. Now, technology is enormously empowering. One of the areas where we have really experimented very successfully, particularly in Delhi, is in setting up virtual courts. So the petty traffic offenses are now being dealt with entirely by virtual courts in Delhi. And as many as 2.7 million traffic tickets have been handled by these courts. And about 1.2 billion rupees has been collected by way of fine by the virtual courts. Now, that just shows you what technology has done to us. Technology is really empowered. Going into really the quality of justice, I believe technology has been a great leveler, particularly for young lawyers and particularly for women. And I see a lot more women participating in the proceedings before the Supreme Court of India. Court proceedings are not, it's difficult for a woman otherwise, because you may not know what time your case is going to be called out. You might have to spend the whole day in a court and your case may not be called out necessarily. When you're online, you know that, well, this is my slot to argue the case. And I find a lot of young women who are now approaching the Supreme Court, arguing across the country. We have lawyers from all over India addressing us in the course of the pandemic. Having said that, there is a problem which we have, and which is the technological divide. Not everyone in India has a smartphone. Not everyone in India has access to the internet. So just as we have depended on technology to deliver justicing services to common citizens, we're equally cognizant of the fact that access to technology is not uniform. So our answer to that is that we are now trying to take technology to the doorstep of our common citizens by ensuring that in every court complex in India, we provide an e-resource center, and these have already started coming up, where basic facilities for digital literacy, for access to the internet, in terms of e-filing facilities, video conferencing facilities would be available. All our jails, for instance, in India have video conferencing facilities. So the jails are connected to the courts. So if a prisoner has to be produced before the court for remand applications, for instance, that can be done on the video platform. The first remand is, of course, always desired to be in the physical form, where you want to know whether the prisoner has been unfairly treated. So having talked about the virtues of technology, we also need to understand that in a country like ours, technology also is suffering from a great divide. But having said that, I still believe that technology is a tremendous source of empowerment. Equally, a lot of children have had to drop out of school because of want of access to technology. And when they drop out of school, they have to go back to the labor force. So these are some of the sobering lessons which we have learned as well from the pandemic. But there's no going back from our use of technology. And if at all, the pandemic has taught us that technology is going to participate. We're going to participate in the court processes through the use of technology in a very big way. Some of our high courts have also started live streaming their proceedings. The Gujarat High Court recently started live streaming their proceedings. That's a work in progress. It's something which is really at the experimental stage at this present point of time. But all in all, I think the pandemic has provided an enormous opportunity to us to reform what was essentially a structure which was creaking at its hinges. And technology has given us a new avenue for making ourselves into a more modern and efficient judiciary in India.
Thank you, Justice Chandrachud, for underlining some of the positives and for your very candid comments. Turning to Professor Laurence and changing fields a little bit, as the director of the MIDS program at the University of Geneva, could you highlight the impact of COVID in academia, especially given that this disruption does not seem to have any sort of end in sight?
Thanks. First of all, I'd like to say that a lot of European countries should learn from the Indian experience in terms of the hearings and the fact, because during the first wave of the COVID, a lot of the courts were stopped and didn't do anything. And we also have a digital divide in our countries. So we have to learn from India, that's for sure. Now coming to the myths, the first thing I'd like to say is that health is very important. Education is also very important. So there I'm speaking of a university program, which is training in dispute settlement. And we have a lot of Indian students coming every year to Geneva to be trained in the MIDS. What we've learned is that, in fact, we thought that having the students in a classroom was very important, but we also discovered that we should develop an online program. And we developed an online program, and we have students from India in this online program. Now, the people in Geneva, it's great to have them, and we cherish them. But last week we had to go through a lockdown. So we went through live stream. And in fact, what we're going to do with them is to teach them how to use the web and how to be trained for hearings on the web and so on. So in a way, the opportunity is that we're going to be learning new things. And having been an arbitrator, sitting as an arbitrator and sitting in the same room where I am today and listening to a lot of hearings, I do feel that that can be done, and things that we didn't think were possible are now possible. And in a way, for me too, and I think I go back to what Justice Chandrachud said, it's a level playing instrument, because in a way, everybody's entitled to express its case or her case, and has time to do that. So what the other insight that I can draw from this experience is that I don't think we're going to go back to what we had before. Things are going to change dramatically. But, and that's going to be the concluding part, it seems, for me, it's also very important to have students in a classroom, and we will continue to have this. Thanks.
Thank you for your comments. Now coming to the last question of this evening, I realize that we're very short on time, but having the benefit of such eminent and inspiring personalities with us today, we realize it's a very great opportunity for learning for the rest of us. And so it would be wonderful to know what gives you all the resilience to push boundaries, what motivates you, and what motivates you to bring about the incredible impact in society that you all are bringing about. Justice Chandrachud, if you could share your journey from India to Harvard, the LLM to SGD, from being a counsel to Additional Solicitor General to Chief Justice of the Allahabad High Court, and now the Supreme Court, that would be great.
You know, I think you've summed it all up. And I don't know where to begin, actually. And I have a space of maybe a minute or two to just say what I have to say. But I think it's been a very rewarding journey, because I think the greatest reward of a life in the law is its fundamental interconnect with society. The law as a discipline has no independent existence of its own, divorced from its societal connect. But I think that may be for some a criticism, but for me, that's the greatest reward of law. That when you're operating within the framework of law, you're in that sense impacting upon real lives and human lives. And in that sense, I think my journey, both as a lawyer, I was a law teacher as well, but as a lawyer and now as a judge, has taught me two different ends of the spectrum. As a lawyer, you come face to face with injustice when you meet real clients, and you see what can happen to an individual when they are unfairly arrested, when they are subject to arbitrary procedures, maybe for the denial of a pension, a denial of a job or whatever. And when it comes to judging, so lawyers have a very vital role to play in a democratic society, because that sense of a fearless advocacy is a great bulwark for freedom, I believe, in democratic societies across the world, whether it's South Africa, it's India, or any of the other countries as well. Insofar as a judge's life is concerned, it's very different from being a lawyer. One of the great things which you miss when you become a judge is the camaraderie of being at the bar, because judges lead very isolated lives, and that's something which you require time to get used to. It grows in you, and now that I'm in it for the last 20 years, I wouldn't have it any other way, because it gives you a little time to reflect, time to introspect, a time to think about the way forward for your society. And particularly in the Supreme Court, I think the great liberation of being in the Supreme Court is that, yes, you are bound by precedent to a certain extent, but then you also are not bound by precedent to the same extent as, say, you would be in the High Court or in the District Court. So the great liberation I feel at an intellectual level of being in the Supreme Court is the ability to contribute to causes, to outcomes which you feel would promote the constitutional values of fraternity, of human liberty, of the ability of human beings to express themselves, of equality and dignity of individuals. Now, for all the cases where you see this quest or this aspiration for justice, you also have a very sad feeling at times as a judge of the Supreme Court when you see injustice, because every case that you see, you come face to face with injustice. So a judge's work in that sense is very edifying. It's extraordinarily satisfying. But then you also have your moments of internal crisis when you look at the extent of injustice which cases show you. And you go back with a realization that, much as though your life, which you've chosen, this path that you've chosen in life has been well worth it, every moment of its time, there's so much which you can do, and there's so much which really remains to be done, particularly in poor societies like ours, and of the work in progress. So it's empowering, but it's been a truly humbling experience as well about the extent of the path which lies before us. And it's also a reminder for us that, we're holding a baton at a particular point of time, and we're all pilgrims in this path. And there comes a time when you hand over the baton and you only hope that, you've been instrumental in creating a new generation which will take over and do a much better job than you did in your time.
Wow, thank you for sharing that, Justice Chandrachud. Over to you, Dr. Turk. You've worn multiple hats, working in a career spanning from law to domestic and international politics. You've been in some of the most important rooms in the world, working on global peace and security. So could you share your journey and the work you do now, especially with the Danilo Turk Foundation, which works to rehabilitate children in high conflict areas?
Well, as your list suggested, it's easy to get confused when one looks backwards to the various stages in which things have happened. But, there is one thing that I used to say to my students when I was teaching, and I often had to discuss with students individually or in groups about their plans, because young people usually, when they are choosing their diploma work or their the theme of their doctoral dissertation, they have to put this in the context of their thinking about what they want to do in life subsequently. And I always told them that it is incredibly important how they define their approach, what kind of trajectory they choose during the period of their higher education. Which direction they want to go, because they will realize only later what their choice actually meant at the time when they were choosing their professional specialization, their their trajectory in short. Of course, my example is not very typical, because when I was preparing my doctoral dissertation, I had 3 different areas in mind, and I was thinking for about 1 year only about which one to choose. I took 1 year to simply think about which one I should choose. I was thinking about something from the law of treaties, something from the law of the sea, which were both very fashionable in early 1970s when I was doing that, and then non-intervention in the context of the use of force by states. I chose the last one. I really had a feeling that this is something really quite interesting, and I was very curious, and so I chose that one. And then obviously things happened. I didn't plan any of them. But when Slovenia became an independent country, and I had already some experience in human rights law and human rights politics, I was asked to go to New York to represent the country in the UN. There was this opportunity to be elected to the Security Council, which again succeeded. And then Kofi Annan invited me to join his team for in the area of political affairs. So you see, one thing leads to another. And I think the key is this. When you are young, especially when you are in the higher education, university education, you have to spend enough time or take enough time for really careful thinking about the trajectory you want to choose. And then you start, and then life will bring opportunities, life will bring necessities. I mean, sometimes you would not be able to choose, otherwise you will be able to choose. And that's how it continues. Now, in my case, it meant a lot of diversity. But I know that not everybody has the same kind of destiny. I once had a brilliant student, a young lady who was finishing her studies and wanted to do a diploma work on International Atomic Energy Agency, something related to the inspections and such things. She did wonderful work. And I asked her, what is your next plan? Are you going to seek a job in Vienna at the agency? She said, no, I'm going to my father's law office, and I will be dealing with real estate. And I asked her, well, that's rather strange. I mean, why did you choose then the International Atomic Energy? And she said, well, I already knew that I will inherit my father's office, and I will be dealing with real estate most of my career. So before that, I wanted to do something different and something really interesting. I told her, look, if life changes for whatever reason, and if you come back to International Atomic Energy Agency, call me and I will try to talk to people in Vienna and see what we can do. I said, sure, I will do that. And I have many friends in Vienna now, so I can take care of that myself also. So she was very self-confident. She very well knew what she will be doing and how she wanted to create a kind of diversity in her life. So I think that that's critical. And then everything else comes as a result of events which you cannot predict and where you will have to make informed choices as you go. So this is my story. I don't have much more to say.
Thank you for sharing that with us. That was very insightful. Turning to Professor Laurence, could you share with us how you balance a career in academia, a practice in international law and in international dispute resolution, while also holding many advisory positions?
I don't know if the word balance is the right word for all this, but I'd like to give you a few insights and to continue with what my predecessors have said, and because I'd like to speak to young people, because you're the next generation to be the one to guide us. First of all, I think life is not a straight line. And what you do today might not be what you're going to be doing in 5 days, 5 years from now, and so on. So when I see young people who are obsessed with, doing something, I always tell them, look, there are different ways of going where you want to go, and keep that in mind. The second thing I think, which is very important, is to like what you do. I think it's so important, because if you like it, you can give as much as you can. And I like teaching. So for example, that's very important. And I like to be involved in practice. The third element that I think is important to me is that I need to feel that what I do is useful. That is very important. So I share an experience that I had with Dr. Turk when we were, and with Diana, when we were working on a report and on the management of fresh water. There I felt that we were doing something useful, and we gave as much as we could so that to make recommendations that could be implemented. And the last insight that I would give is that don't forget real life. And I think it's very important to be grounded in real life, to speak with your neighbor, to do other things, to see a movie and so on. So to see that what you're doing is important, but it's not that important in comparison to what others are doing. Thank you.
Wow, Professor Laurence, thank you so much for that. And thank you both, also Justice Chandrachud and Dr. Turk. It was absolutely, there's so many lessons there, and we have so many takeaways from there. With that, ladies and gentlemen, unfortunately, we've come to the end of the Fireside Chat. We've already exceeded 6 minutes, and I can't keep the speakers any longer. I can see a lot of questions. Maybe the next time we can do a part 2 of this Fireside Chat, and we'll get them to answer these questions. But thank you all for joining this session and making it a memorable experience. Thank you to our media partner, Bar and Bench, and our strategic partner, Daksha Fellowship. And above all, this event would not have been possible without our incredible speakers. So a big thanks to Dr. Turk, Justice Chandrachud, and Professor Boisson de Chazournes for joining us and for making this event such a success. Thank you.
Thank you very much.
Subscribe to our YouTube channel and click the bell icon.